Liberty Nation with Tim Donner.
And now, finally, we have reached the ultimate section of Liberty Nation Radio, which we entitle Talkin' Liberty. It is when we reintroduce our regular contributor, constitutional lawyer, LibertyNation.com legal affairs editor, and our guardian of individual liberty, back in the saddle, back in Studio A. Ladies and gentlemen, Scott Cosenza.
We may technically be within 6 feet of one another, too, Tim. It feels good to be here. Thank you.
Technically, if you're watching the video, I think you can judge that we're about 6 feet, 2 inches apart from each other,
right.
just to be safe.
For the governor's sake, we'll say that's right.
Yes, for Governor Northam. Now, Mike Flynn. I know you mostly want to discuss this Flynn case from the angle of Judge Emmett Sullivan's call for arguments in opposition to Mr. Flynn, charges against whom were dropped this week.
Well, they're not. It's a question about whether they are actually dropped, right? There's a process, and part of the process involves a judge entering an order sort of confirming the dropping and dismissal of charges. And before he does so, Judge Sullivan has said he wants to hear from people who want to argue that he should not do so in the form of an amicus brief. I find his call for these arguments to be very disturbing. You know, federal judges, Tim, can do all sorts of things that aren't specifically prohibited to them, but are horrible ideas and work against, I think, notions of justice. And Judge Sullivan has every month in the many, many months this case has gone on, has rejected people's attempts to file amicus briefs in the case. A judge doesn't have to accept them. And all of a sudden, when now we have the disclosure of the unmasking reports, further indication that it was a political railroad job rather than a legitimate, attempt to get justice in the face of criminality, you'd think that the judge would sign off on it.
How common is it for a judge to reject the amicus brief, which basically means a friend of the court brief trying to project a certain position?
It's an interesting question. They're not usually submitted in individual criminal trials. They're usually submitted, Tim, when larger issues of constitutional law are being decided. So in an abortion case, a gun control case, these sorts of things is where we see groups filing amicus briefs. But for an individual criminal defendant, it's very much atypical. I had never even heard of it. I didn't even know it was a thing. I did look into the law, and it seems like Judge Sullivan's order is not, on the face of it, illegal or against other court precedent. And that doesn't mean it's consistent with Mr. Flynn's constitutional rights. That still could be violative of them. I just mean he's not a total maverick here, but that doesn't mean it's okay or a good idea.
Well, we're gonna hear more about this Flynn story. It hasn't gone away, and both sides want to talk about it for obviously opposite reasons. Meanwhile, Scott, a federal judge has rejected plea bargain deals that limit compassionate release, calling them appallingly cruel.
Well, I think this is a great opportunity for, federal judges often exercise independent authority in dealing with these judgments in a good way for and upholding the rights of the accused. So in this case, Charles Breyer, who's in the Northern District of California, rejected a plea deal which required, you have to remember, in any type of plea deal, and just like in the case with Mr. Flynn, the government's in the power position, right? They're the ones calling the shots by and large. And if you want the deal, you kind of have to agree to what they say. And part of what they do, Tim, is to restrict rights on appeal. And in this case, not only just rights on appeal, but compassionate release rights. And so what that means is if somebody has, for instance, a terminal illness, and they're basically going to be dying in a month or two, they can appeal to the Bureau of Prisons and maybe get out of jail or prison for that last month or so of their life, which, by the way, is not only good for the incarcerated person. They're not likely to reoffend in that time, but it's also good for the federal system to not have to bear the burden of that care, by the way. So it's kind of a win-win. But the problem is those people aren't rewarded for getting those folks out of prison, and so they drag their feet oftentimes, just bureaucratic process. Well, the federal prosecutors want to limit the right of the people to appeal that process. at their sentencing. And so what they do is they say, okay, you want a deal? Here, we'll give you this deal. Also, you're going to waive all these rights. And the judge says, you can't waive that compassionate release right. It's absolutely appallingly cruel. And I just thought it was an interesting juxtaposition to Judge Sullivan, right, who is working to frustrate the rights of this person who was in his court, rather than Judge Breyer, who is working to kind of bolster the rights of the accused and uphold kind of a more lofty, I think, notion of justice there.
So we have presented, in a sense, a yin and yang of the federal judicial system. But you spent an awful lot of time this week, Scott, on the case of Ahmaud Arbery and a video that surfaced that has gone viral and created an explosive, yet another explosive racial situation.
That's right, Tim. Sadly, it looks like we have another tragic case where somebody was killed or maybe murdered, but that also that killing or murder is being used to basically drive a frenzy of reaction that it was a racially hatred-motivated crime, which there is yet to be no evidence for whatsoever. I wanted to say this, too. Because of the way that the shooting went down, I wouldn't be surprised if the McMichaels are going to perhaps be acquitted of murder. And it has to do with the very last seconds of Mr. Arbery's life and what may have happened there.
And what do we know?
Well, what we know is that there was a chase. We know that there was a physical altercation, whether Mr. Arbery at the final moment of his life charged into Mr. McMichael is, I think, in dispute, and also whether or not that would make any self-defense claim void or moot or empower it, Tim. These are all things that have to be kind of worked out with a very slow, careful look at the evidence. You know, the idea that we can just automatically say this was a lynching, I think, is beyond the pale. It was certainly not any kind of lynching. Now, it may have been an illegal killing, but also perhaps not.
I have a feeling we're going to find out a lot more about this in the week ahead. We'll probably talk about it next week.
Sounds good.
Thank you, Scott.
Thanks, Tim.